So get ready to put on your legal eagle glasses.
Okay.
Because you have sent over a stack of documents that are, well, they're straight out of a courtroom drama.
Yeah.
We're talking motions to disqualify judges, arguments about bias. We've even got personal accounts of perceived injustices within the legal system.
Yeah, it's pretty fascinating how these documents, they kind of represent this really like diverse range of attempts to navigate the system, and to hold judges and other legal actors, accountable for their actions.
Because everyone's trying to find their own way to shout, objection,
Right.
but in a way that actually gets heard by the court.
Exactly. Yeah.
So our mission, if you will, is to take a magnifying glass to these documents. We're going to untangle the strategies at play, try to figure out what they tell us about, the balance of power in the courtroom.
Yeah.
And see what lessons we can maybe glean about seeking justice within a system that can sometimes feel, well, anything but.
Within a system that's, well, it's designed to uphold its own power structure.
Exactly. And I think there's no better place to start than with a case that kind of threw this whole issue of judicial bias into the spotlight.
Okay.
The case of General Flynn.
Right. Yes. The motion to disqualify Judge Sullivan in the U.S. v. Flynn case.
You're right.
This document, this is a fascinating example of how documents are crafted not just to present the facts, but to really like sway opinions and to create a narrative.
Law and procedure. And they even said that the judge, quote, abandoned any pretense of neutrality. That we're not mincing words.
No, and that's no accident.
Yeah.
The attorneys who, put this motion together, they knew they had to grab attention.
Right.
They're trying to persuade a higher court that Judge Sullivan's actions weren't just, questionable. They were so egregious that it tainted the entire proceedings, the whole thing.
So it's not just about presenting facts, it's about creating a story that resonates.
Exactly. And they build that story by very meticulously listing what they see as Judge Sullivan's missteps.
Okay.
Especially during sentencing.
Wow.
They even go so far as to accuse him of essentially becoming a party to the case himself.
Oh, wow.
Rather than an impartial arbiter, like a judge is supposed to be.
Right, and that's where that whole 455A thing comes in, right?
Yes.
I did a little digging, and that section of the law basically says judges have to step back if there's even a hint of bias.
You got it. Yeah. But here's the catch.
Okay.
Proving actual bias.
Yep.
Incredibly difficult.
Right.
So the Flynn motion, what they do is they focus on the appearance of bias, arguing that Judge Sullivan's conduct, even if it wasn't intentionally biased, would still lead a reasonable person to question his impartiality.
So it's about public perception too. Like, even if the judge believes they're being fair, if it looks bad, that's a problem.
Precisely. It's about maintaining public confidence in the judicial system.
Right.
But, and you can imagine this, right? But trying to prove something as subjective as the appearance of bias.
Yeah.
It's like trying to catch smoke.
That makes sense, but it also feels incredibly difficult to prove.
Right.
It makes you wonder, like, what strategies are even available when you feel like a judge might be biased.
Right.
But actually proving it feels almost impossible.
Yeah. And that brings us to another document you shared. Arguing Judicial Bias and Appeal from a Defense Attorney with the .pdf. And yes, I know, the title is a bit of a mouthful.
Just a tad. I have to admit, when I first saw that title, I thought, okay, this is where it gets really legal heavy.
Understandably so. But honestly, while the title might sound kind of intimidating, the document itself, it's like a roadmap,
Okay.
It helps you understand how attorneys might challenge judicial bias on appeal.
And it's fascinating how they connect those like broader legal strategies to real world cases, right?
Absolutely. They weave in cases like Chapman v. California, People v. Abasade, and People v. Whalen, just to illustrate how, these kind of abstract legal principles have played out in actual courtrooms with real people, impacting their lives.
It's like they're saying, hey, this isn't just legal theory. This is about people who felt wronged by the very system that's supposed to deliver justice.
Exactly.
And that's a powerful way to connect the dots, don't you think?
It is, because it reminds us that behind every legal argument, every motion, every appeal, there are individuals who are seeking fairness, accountability, and ultimately, a system they can trust, that they can believe in. That's what it's all about.
It's interesting, though, because we've been focusing on, these formal procedures, motions, appeals, that sort of thing.
Yeah.
But you also included some documents about attorney misconduct complaints.
Right.
I'm thinking about this one. Be Free 1051 sign, bar grievance reasons what? Texas attorneys commonly.pdf. Is this another avenue for like challenging a judge's actions?
It can be.
Okay.
So it's not always straightforward.
Right.
While bar grievance procedures, they're mainly focused on attorney misconduct. This document, what it does is it highlights how those procedures, they sometimes kind of overlap with complaints about judges.
So if an attorney believes a judge has acted unethically, they might file a grievance with the bar.
Exactly. And those grievances, what they can do is they can shed light on maybe like patterns of behavior or even systemic issues.
Interesting.
That might not be evident in just a single case. You know what I mean?
Right.
So it adds another layer to this whole web of accountability that we're trying to untangle.
It seems like you'd almost need a legal playbook to navigate all of this.
Right. It's a lot.
Especially when you consider those personal accounts we talked about earlier, like JSC complaint 2.pdf and JFC criminal complaint.pdf. Those felt so raw, so full of frustration with the system itself,
Yeah, and those documents, what they do is they highlight a really crucial contrast.
Yeah.
On the one hand, you've got these like meticulously crafted arguments from attorneys, right? Who are operating within these established legal framework.
Right.
And on the other hand, you have these individuals and they often feel compelled to represent themselves.
Yeah.
And they're drawing on whatever legal knowledge they can just to try to get their voices heard.
It makes you think about like all those people who maybe don't have the resources to hire these expensive lawyers.
Right. Exactly.
Or maybe they aren't as familiar with the legal system in the first place. What happens to their stories,
That's a question that kind of echoes throughout a lot of these documents.
Yeah.
And it actually brings us to another really important concept that we see in a lot of legal systems.
Okay.
Judicial immunity.
Right.
Judicial immunity, Duke 2.pdf.
Right.
This document gives us a deep dive into this, this principle that a lot of people, I think, misunderstand.
Yeah, judicial immunity. It's like this, legal shield almost that protects judges from being sued for every decision they make.
It's true.
But the document you shared, it makes it clear that it's not as simple as it sounds.
No, not at all. Yeah, this concept of judicial immunity, it goes back centuries.
Wow.
And it exists for a reason.
Okay.
To protect the independence of the judiciary.
Right.
Judges, they need to be free to make decisions based on the law.
Yeah.
And their interpretation of the facts without being afraid of getting personally sued.
Right.
By unhappy litigants.
That makes sense, but like you said, it's nuanced.
Yeah.
The document talks about judicial acts versus ministerial acts.
Right.
What's the difference? And why does it even matter?
That distinction, it gets to the heart of what judicial immunity is supposed to protect.
Okay.
Judicial acts, those are like the core functions of being a judge.
Got it.
Things like issuing rulings, interpreting the law, presiding over trials, basically all the stuff that we usually think about when we think about a judge.
Right.
Those acts are generally protected by immunity.
So even if someone disagrees with a judge's ruling, they can't just sue the judge for it.
Generally, no. That's the whole point of immunity.
Got it.
Now, ministerial acts, on the other hand, those are more administrative.
Okay.
More clerical. Okay. Think about things like filing paperwork, scheduling hearings.
Okay. Got it.
Those acts, they're usually not covered by judicial immunity.
It makes you wonder though about those gray areas,
Oh, absolutely.
Where do you draw the line between a judicial act and a ministerial act? That seems
that's
kind of blurry.
That's where it gets really tricky, and honestly, it's part of what makes this document so fascinating.
Okay.
It goes into the history of judicial immunity, and it uses all these different cases, like Floyd v. Barker, Miller v. Sear, and Bradley v. Fisher, just to show how courts have been wrestling with these really tough questions, literally for centuries.
So it's not all, and this is constant forth between protecting judicial independence, but also holding judges accountable.
In a balance,
You said earlier about for seeking justice.
Right.
When those traditional paths they don't seem to be working.
Yeah. When you hit a wall.
What are some of those alternatives? What do you do?
Well, that's where I think things get really interesting.
Okay.
Because we start to move beyond the walls of the courtroom.
Okay.
Documents like kobachgrandjury.pdf, sdfinalcomplaint.pdf, and even how to bring justice to judges.pdf. These illustrate some of those paths that are a little less conventional.
Okay, let's unpack this.
Right.
What are we looking at with the Kobach grand jury petition?
So this document, it gives us a glimpse into the possibility of using grand juries to investigate these allegations of judicial misconduct.
Got it.
It highlights just how difficult it can be to hold powerful people accountable.
Yeah.
Even when the public is practically demanding scrutiny.
So it's a high bar to clear.
Oh, absolutely.
Trying to get a grand jury to even look at a judge's actions.
Exactly. And then we have sdfinalcomplaint.pdf.
Okay.
And this shows us another route you can take.
Okay.
Using civil to challenge those in positions of power. In this particular case, it's a complaint that's been filed against a city government.
Okay.
Alleging misconduct to address some pretty serious issues.
they like highlight the power imbalances in our legal system.
Oh, yeah.
We've got individuals going up against like entire government,
True.
citizens taking on these really powerful institutions. It's, I don't know, it's a bit David versus Goliath, isn't it?
It really can feel that way.
Yeah.
And then we've got how to bring justice to judges.pdf.
Oh, okay.
And this one takes a more, I guess you could say, a more grassroots approach.
Okay.
Even maybe a little bit activist.
Okay.
It outlines different strategies that citizens can use to challenge judges.
Okay.
Things like public campaigns, trying to get media exposure, or even running for office themselves.
So we've got grand juries, we've got civil lawsuits, public pressure campaigns.
It's true.
It seems like there's like a whole arsenal of tools available for people who are really, you know, ready to like fight for accountability.
It's true. And these documents, they show us that seeking justice, sometimes it means thinking outside that traditional courtroom box.
Yeah.
Sometimes it's about like shining a light on these systemic issues,
yeah,
demanding transparency, and really empowering citizens to hold those in power accountable.
Speaking of shining a light, one of the documents you shared, disqualification contributions.pdf, this one gets into a really, I think, really timely issue.
Yes.
Campaign contributions and whether or not they can influence judicial decisions. Yep. Because it feels like we hear more and more about this these days.
Yeah, it's definitely gained a lot of attention, especially in recent years.
Right.
And this document, it really digs into this concern over the influence of money in judicial elections.
Okay.
And especially in light of that landmark Supreme Court case.
Yeah.
Caperton v. Massey Coal Company.
Right, the Caperton case. That was the one where a coal company executive spent millions of dollars to help get a judge elected, and then that judge later ruled in his favor.
Yep.
Didn't that case really, like, I don't know, set off some alarm bells about potential conflicts of interest with campaign donations and judges?
Yeah, the Caperton case, it really, like, it exposed just how vulnerable the justice system can be to the influence of these campaign donations, especially when it comes to, electing judges.
Right, because you're trying to, like, I don't know, buy a judge.
Right, exactly.
And that doesn't sit right.
It shouldn't. No, and the document you're talking about, it looks at all these different ways people have tried to deal with this.
Okay.
Things like, stricter recusal rules for judges, or even trying to put limits on how much money can be given to campaigns in the first place.
So it's about making sure that justice isn't something that you can just buy if you have enough money, right?
Exactly, because if people lose faith that the courts are impartial,
right,
if they think the scales of justice are tipped, then the whole system, it's at risk, the whole thing.
Right, exactly. And that brings us to a document that I think really underscores this idea of needing a system that's fair and impartial.
Right.
Joshua Bellamy-complaint.pdf.
Okay.
This one, honestly, it reads like something out of a movie, like a legal thriller or something. You've got allegations of fraud, forged documents, this whole network of people who are accused of basically trying to, like, game the system for their own personal gain.
Yeah, it's a wild one.
It is.
And this document, I mean, it's a really stark reminder that justice isn't just about protecting innocent people.
Right.
It's also about holding accountable those people who try to exploit the system.
Yes, exactly.
And in this complaint, they lay out this whole case, very detailed, alleging this complex scheme to defraud the government through these fraudulent PPP loans.
It makes you appreciate, like, the work of the people who have to investigate these things.
Oh, absolutely.
They follow the paper trail, they connect all the dots.
Yeah, it's a lot of work.
And then they work to make sure that the people who are breaking the law are actually held responsible.
Yeah, because a system that doesn't have any consequences for doing something wrong, that system's not really protecting anyone.
Right, exactly. And I think go ahead.
Oh, I was just going to say that brings us to our last document. And this one takes a very, I guess you could say, more provocative approach to this whole idea of challenging authority.
You're talking about law, how to bring justice to judges.pdf, right? This one really caught my eye. It's like, okay, what happens when those traditional ways of getting justice, they're not enough?
Exactly. This document, it wants us to think beyond those established procedures to consider maybe some unconventional methods for dealing with judicial misconduct.
Interesting.
It reminds us that even though the legal system is built on precedent, on all these rules and procedures, it's really up to us as citizens to make sure that justice is actually being served.
It's like that old saying, the price of freedom is eternal vigilance.
There you go.
But it's applied to the legal system,
Absolutely. You can't just assume the system's going to keep itself in check.
Right.
We have a role to play in holding it accountable.
And that is, I think, what makes this whole collection of documents so fascinating.
I agree.
We've gone on this journey through the courtroom and beyond.
We've seen it all.
We really have.
Motions, appeals.
We've seen how people have used legal motion.
Grievance procedures, even public campaigns.
Appeals, grievance procedures.
All to try to make the system more transparent, more fair.
Public campaigns, to push for transparency, to push for fairness.
It's amazing what people can do when they set their minds to it.
It really is. And, if there's one thing that I hope our listeners take away from this whole deep dive.
What's that?
It's that understanding the law questioning authority, advocating for justice. Those aren't just things for lawyers and judges.
That's right.
Those are responsibilities that we all share.
We all have a role to play.
Exactly. So, to our listener, as you continue to explore these issues,
stay curious.
As you face injustices, whether it's in your own life or in the world around you,
don't be afraid to speak up.
Remember, you have a voice, you have agency, you have the power to make a difference.
Keep learning, keep questioning.
Keep questioning, keep learning, and most importantly, keep diving deep.